third and final day of our sitting this week. 3 cases on today's docket. We're going to start off with 23-60027, Citizens for Clean Air and Clean Water in Brazoria County via the U.S. Department of Transportation et al. So whenever you're ready.
Good afternoon, Your Honors. May it please the Court. Devorah Ancel, on behalf of the community and environmental petitioners challenging MARAD's licensing decision of the Seaport Oil Terminal, known as SPOT. SPOT would be the largest ever deepwater port in U.S. waters to export crude oil, allowing tankers the size of the Empire State Building to load up to 2 million barrels a day of crude for shipment to the global market. For 30 years, the license allows the export of 18% of U.S. produced oil without justification for what that means for our nation's energy reserves. SPOT's massive quantity of throughput would cause carbon emissions equivalent to operating 80 new coal-fired power plants. And along with SPOT's hundreds of miles of on- and offshore pipelines comes significant harm to the health and livelihoods of thousands of local residents living close to SPOT's expansive infrastructure. For years, Surfside and Freeport community members, some of whom are here today, have raised concerns about the numerous threats SPOT poses to them, which remain unaddressed. Today, I plan to discuss the agency's insufficient air quality and species impact analyses that violate the National Environmental Policy Act and MARAD's omission of a key Deepwater Port Act licensing factor. These violations and the agency's egregious 630-day delay beyond the statute's strict decision-making timeline are serious violations requiring vacature and remand of the licensing decision. Before turning to the merits, I would like to highlight for the Court some of SPOT's on-the-ground harms. The record shows that SPOT is expected to spill hundreds of times on and offshore during its 30-year operation, coating large swaths of the coast in waters that will cause damage to personal property in Texas's iconic beaches. SPOT's ozone pollution will exacerbate the region's already severely impaired air quality, worsening asthma and respiratory illness that already plagues local communities. And daily lives will be disrupted from traffic and noise during SPOT's years of construction. Turning to the merits, MARAD's review of SPOT's impacts violated the National Environmental Policy Act's hard look requirement. And of the significant flaws the petitioners raised, I would like to highlight for the Court the clear-cut omission of ozone pollution from the hundreds of tankers that would serve SPOT each year. NEPA requires the agency to calculate the total pollution from all of its emission sources and explain how that contributes to regional ozone and compliance, or in this case, non-compliance with the federal ambient air quality standards. This region is designated as severe non-obtainment for ozone, and it is undisputed that the agency did not calculate ozone pollution from the vessels either individually or cumulatively with the nearby Texas Gulf Link export facility, which is sited 7 miles away in the same severe non-attainment ozone region. The agency had the data and tools to make this critical calculation. It shows that nitrogen oxide pollutants, that's an ozone-forming pollutant from the vessels, is 3 times what the agency used to calculate offshore ozone pollution for just the platform alone, to reach the conclusion that air quality impacts would be less than significant. Clearly, this is a significant contribution to the ozone pollution that they failed to quantify or disclose to the public and decision makers. This is just like the DC Circuit's case in Vecinos and the 10 circuits in DNA Citizens, which affirm the NEPA requirement to calculate total ozone from all of the pollution sources, both individually and cumulatively. And like here, Vecinos involved mobile and stationary sources, and the agency there went beyond the Clean Air Act permits to calculate and explain total ozone contributions to the region. This calculation is a critical component to NEPA's public disclosure requirement and to ensure decision makers have a complete understanding of the project's scope of impacts. MARAD erred in relying on just its Clean Air Act permits to conclude that air impacts would be less than significant. Those permits only encompass the stationary platform source and the onshore facilities. They did not include the hundreds of vessel tanker pollution, the pollution from the hundreds of vessel tankers serving SPOT each year. The DC Circuit in Sierra Club versus FERC 2017 affirms that Clean Air Act permits overseen by another agency, the EPA, does not substitute for the required NEPA analysis to evaluate total ozone and explain how that contributes to the regional air quality. Lastly, on this point, the agency omitted the critical next step of explaining how SPOT's ozone pollution would contribute to the on-the-ground health impacts, including how it would exacerbate asthma rates and respiratory illness that already plagues communities that are in the severely impaired air quality region. This court in Gulf Restoration versus Department of Transportation in 2006 provided that the EIS must have sufficient detail for those who are not involved in its preparation to fully understand and consider the pertinent environmental influences involved and by omitting the significant source of pollution that did not happen here. I would now like to turn to the EIS's flawed analysis of oil spill impacts on species. This case is just like the DC Circuit's recent holding in Eagle County versus Surface Transportation Board, where they rejected vague conclusory statements of effects as insufficient for NEPA, and they held that the agency was required to quantify and explain all of the project's effects. That may involve some reasonable forecasting and informed assumptions. Here, they never explain the degree of impacts on well-studied species of the Gulf that could occur from SPOT's projected spill. The most likely spill they projected was 2,200 barrels, and the worst-case scenario spill of more than 680,000 barrels. And this was the case for the many affected, protected, endangered, and threatened species of the Gulf. Instead, the EIS more than 80 times makes a similar vague conclusory statement of a possible range of effects. They could be minor or major, direct and indirect, short and long-term, depending on the size of the spill. That does not provide the meaningful explanation of impacts that NEPA requires. The EIS also sends the reader on a wild goose chase to various sections where it purports that additional analyses was completed or more in-depth analysis was completed, but that is simply not there. To provide the court an example, there is a single paragraph in the EIS on protected marine mammals that summarily states the impacts could be minor or major, direct or indirect, short or long-term, and then references the non-endangered marine mammal section and an incorporated biological assessment that leads the reader to pages and pages that turn up nothing of value on how these species would be affected by SPOT's projected spills. They could have taken SPOT's projected spills and tons of underlying data they have on these well-studied species of the Gulf, like mortality rates from past spills, and provided what Eagle County requires, some sort of quantification or projection of the degree of lethal or non-lethal impacts to these well-studied populations. This court in Sierra Club versus Sigler, which was also an oil tanker spill case, provided that the EIS requires the agency to provide a full spectrum of consequences that may result from the project and the details of those protected consequences. That was not done here, and that violates NEPA's express requirement to provide a detailed statement of the project's reasonably foreseeable direct, indirect, and cumulative effects, including the effects of catastrophic consequences, even if their probability of occurrence is low. I would like to turn the court to MARAD's reliance on a post-EIS biological opinion. It includes significant new evidence on the critically endangered Rice's whale, which numbers less than 50 individuals exclusively in the Gulf. This study provides evidence that finds the species actually persistently occurs in the Central and Western Gulf, directly overlapping with Spot's exporting tankers. That biological opinion was published after the FEIS, and there was no opportunity for public comment. This critical evidence implicates the degree of impacts and influences the agency's decision-making. And this matters because every time they mention the Rice's whale in the EIS, they conclude there were no effects. Yes, Your Honor?
What does that constitute a substantial change?
Your Honor, this is a substantial change of circumstances that require them to issue an SEIS, because what that evidence showed was that the whale persistently occurs in areas that overlap with the exporting tankers of Spot that was not previously known during the FEIS process. And because now it shows that they have a direct threat, the Spot has a direct threat of spills, vessel strikes, and underwater noise that was not previously known and not evaluated in the FEIS. And the public, because this was published after the EIS, did not have an opportunity to weigh in on that critical new information. And had we had the opportunity to weigh in, we would have underscored that this finding, underscored the finding that it persistently occurs in the impact zone of Spot that poses these direct threats that weren't previously known. We would have submitted a scientific expert report from one of the nation's most foremost experts on the Rice's whale, explaining that MARAD cannot now conflate the rarity of the species as a whole with the possible frequency of occurrence in the impact zone.
The issue with it is that there was no public comment, not that it wasn't considered by the agency at all.
Your Honor,
Did they engage with the new information at all?
They engaged with it after the FEIS and its comment period closed in their biological opinion, but the reason why it's so important that the public weighs in is because we would be able to have an opportunity to review and provide scientific analysis that may not be consistent with what the agency ultimately concluded on that new information. And had we had the opportunity to weigh in, it may have shifted their conclusions. We would have submitted an expert report that discusses why it's so critical they consider these as stronger threats to the species, and that the scientific community now acknowledges that the loss or irreparable harm to one whale could lead to the species extinction. This all demonstrates that Spot poses a heightened risk to the species. That was nowhere in the FEIS. And circuit courts have held that the failure to include FEIS data or analysis supporting the agency's decision hampers public engagement. I would now like to turn to the Deepwater Port Act claims. MARAD failed to evaluate whether Spot is consistent with the nation's goals of energy sufficiency, which is an express licensing criteria with which the agency must evaluate to determine whether the project is in the national interest. Nowhere in the record does it explain how licensing the export of 18% of U.S. crude will impact our nation's long-term energy, supplies, and demand. And just ticking off the magic words energy, sufficiency in a concluding statement in the record of decision, which is what happened here, does not provide the meaningful consideration of the statute's express licensing criteria. That was the holding in Eagle County versus Surface Transportation Board, where they held that conclusory Vague analysis of express licensing criteria violated the underlying licensing statute. Here, the court has express law to apply, and the APA underscores that the court must evaluate whether the agency considered all the relevant factors that Congress intended it to consider and provide a satisfactory explanation of that, and they didn't do that here. MARAD also can't attempt to explain that post hoc by cherry-picking individual statements out of the EIS that don't directly address energy sufficiency. And that was this court's holding in Reynolds Vapor and Data Marketing, where they rejected post hoc explanation, and Data Marketing went on to say that that post hoc explanation is further evidence of the agency's arbitrary and capricious decision-making. I see that I'm out of time, Your Honors.
Thank you very much. We'll hear from you on rebuttal.
Great.
We'll see you soon. Mr. Peterson. For the Department of Transportation, welcome.
Thank you, Your Honor. May it please the court, good afternoon. My name is Ezekiel Peterson, here on behalf of the United States. My plan is to speak for 15 minutes and then to leave 5 minutes of time for counsel for the interveners, Spot and Enterprise. MARAD and the Coast Guard here conducted a meticulous environmental review and thoroughly involved the public before issuing a final environmental impact statement and record of decision approving the Spot Deepwater Port license application. Petitioners take issue with the outcome of this decision, but they have not shown that the agency's process in reaching this decision was deficient, as they must under NEPA. The agency has in fact complied with NEPA and the Deepwater Port Act, and this court should affirm the petition. My plan is to start by discussing how the agencies took a hard look at the different environmental consequences and risks of the Deepwater Port, before then discussing why MARAD complied with the Deepwater Port Act itself. First, as to the NEPA claim, the agencies here took a hard look at the environmental consequences of the port, compiling an environmental impact statement, or EIS, that ran nearly 900 pages and incorporated 3,600 pages of additional appendices and supporting analysis. With respect to the oil spill risk and consequences, the agencies took a hard look at the risk, consequences, and environmental effects of many different sized oil spills. The FEIS includes spill risk profiles that analyze the likelihood of risks of spills ranging everywhere from 17.5 barrels to 687,602 barrels, which was the worst case discharge. That's at record page 24002 and 24003. Petitioners here are wrong that the agencies only looked at the effects of a 2,200 barrel spill. The agencies determined that a 2,200 barrel spill was the most likely large spill from the port, so that's what they focused their analysis on. But they actually analyzed much more than that. They quantitatively modeled the effects of an oil spill and the PAH, or polycyclic aromatic hydrocarbon, concentrations for both a spill of 2,200 barrels and the worst case discharge of over 600,000 barrels. That's at record 23577 to 23579. They also qualitatively described the effects of an oil spill on each one of the biological resources that they analyzed in the EIS. So that's wildlife, marine mammals, benthic resources, plankton, marine fisheries, freshwater fisheries, and others. The agencies also modeled the trajectory of both a 2,200 barrel spill and a 600,000 barrel, or more than 600,000 barrel worst case spill. That's at 26,630 to 34 for the worst case spill and 23,965 to 66 for the 2,200 barrel spill. In doing so, the agencies analyzed the effects of a spill under 12 different hydrometeorological conditions, creating profiles that predicted where a spill would occur and where the oil would spread under different scenarios. So it's not true that the agencies took a cursory look at the oil spill risk and consequences here. Yes, they focused on a 2,200 barrel spill because that is what they determined the most likely spill would be for a large spill. But they looked at much more than that. And the lenses with which they looked at the effects and consequences of the oil spill allowed them to take a good faith, objective, hard look at the risk and effects of an oil spill. That's all that NEPA requires. As to the Deepwater Port's effect on species, including the Rice's whale, The FEIS concluded that the port was not likely to adversely affect the Rice's whale. After this 2022 study that petitioners cite came out, NIMFS, which is the government's expert agency on marine wildlife and marine fisheries, compiled an extensive biological opinion that explicitly took into account that study and reached the exact same conclusion as the EIS. That's at 208-324. The agencies would have only been required to have compiled a supplemental EIS, which would have been up for public comment if there was some sort of new information or changed circumstances that affected the quality of the human environment in a significant manner or a manner not already considered. And here, the NIMFS analysis of the 2022 study showed that nothing had changed in a manner that would have required a new supplemental EIS. That makes sense when you look at the study itself, which explains that while whales might occupy this northwestern region of the Gulf, overall there seem to be fewer whales or much more sparsely spaced whales in the western Gulf of Mexico compared to the eastern Gulf. That's at 206, 760, 774, and 776. So the BIOP concluded the same thing as the initial EIS. Then the agency's MARAD completed their final record of decision, which again discussed the BIOP, discussed this 2022 study, and came to the same conclusion yet again that the port was not likely to adversely affect the Rice's whale. That's at record 208-591 to 592. The agencies MARAD explained that the port is in shallower water, 100 feet, than the Rice's whale habitat, which is 300 to 1,300 feet. The shipping routes from the port don't overlap with the core distribution area of the Rice's whale. And the extent of the Rice's whale in the Western Gulf, even after this 2022 study, is still unknown. It was not arbitrary and capricious for the agencies to conclude, exactly in line with what NIMFS concluded, that the port was not likely to adversely affect the Rice's whale. Turning to the agency's analysis of the port's ozone emissions, the agencies took a hard look at the port's ozone emissions and determined that the port could in fact result in fewer ozone emissions and less air pollution than the existing reverse lightering export process. Under the existing process, smaller ships that fit on shoreside ports are loaded up with crude oil and then ferried out to larger ships, or these very large crude carriers, to transfer oil in two different steps. Each transfer of the oil produces a large amount of volatile organic compounds, or VOCs, which is one of the primary ozone precursor emissions, along with nitrogen oxides, or NOx. Here, the EIS adhered to EPA guidance by laying out the port's ozone precursor emissions, VOCs and NOx, and discussing precursor emissions from on and offshore sources. The agency discusses that at 23.831 to 32 and 23.838 to 40. Analyzing the precursor emissions is the correct way to look at the ozone emissions from the project because sources don't actually emit ozone. Ozone is formed in these complex photochemical reactions in the atmosphere between volatile organic compounds and light, or nitrogen oxides and light. So when the agencies look at the VOC emissions and the nitrogen oxide emissions, they are looking at ozone, and that's what they did here. Petitioners fault the agencies for not considering the entire project, both on and offshore components, as a single source. But the agencies explained that the components are more than 40 nautical miles apart, and that construction emissions, which account for a large chunk of the emissions of this project, since operational emissions would be less than the reverse lightering process, construction emissions would mostly occur in different years. The agencies explained that at 23.838. The agencies also appropriately analyzed the emissions of on and offshore components separately and looked at both mobile and stationary sources when they did so. The EIS also looks at the cumulative impacts, including the impacts from the Texas Gulf Link project and this project. The EIS includes a robust cumulative impacts analysis when it comes to air quality impacts at 24084 to 24091, as well as a table that lists all the deepwater ports that will be in the near area and those deepwater ports nitrogen oxide emissions and VOC emissions. And that includes the Texas Gulf Link project. So the agencies took a hard look at the cumulative air quality impacts here and concluded that the port would result in negligible short-term cumulative air quality impacts. Again, the agencies took a good faith, objective, hard look at the ozone emissions, the ozone precursor emissions, and air quality impacts from this port, and also determined that the port would not increase the severity of any existing ozone standard violation, which is designed to protect human health. The agencies complied with NEPA when looking at the ozone emissions and the air quality emissions from the deepwater port. Finally, I'd like to touch on the Deepwater Port Act claims that petitioners bring here. Petitioners are not in the zone of interest that Section 5 of the Deepwater Port Act, which includes the timeline provision, was intended to protect. In fact, petitioners benefited from the extended timeline and asked for the timeline to be extended at 45062 to 63. When they did so, they themselves recognized that, quote, the lead agency may extend prescribed periods, such as public comment deadlines. Here, the Deepwater Port Act clearly does not require vacatur as a consequence for the exceedance of a statutory timeline, and this court should not impose it. Petitioner's interpretation would have had MARAD deny the application just 22 days after it was submitted, which presumably at that point, the applicant would have just submitted the application all over again, starting the application process anew, and further delaying the project. With respect to the Deepwater Port Act licensing factors, MARAD complied with the Deepwater Port Act by finding that the port was in the national interest and consistent with the national policy goals, including environmental quality and energy sufficiency. This inquiry is not an inquiry purely about energy sufficiency. The inquiry is not, does the port advance energy sufficiency? The inquiry is whether the port is consistent with national policy goals, including environmental quality and energy sufficiency. It has to be considered in the context of Congress amending the Deepwater Port Act to allow for ports that export crude oil, not just import crude oil. Here, MARAD rationally concluded, was not arbitrary and capricious in concluding at 208-578 to 579 that the port would be consistent with national policy goals, including environmental quality and energy sufficiency. MARAD concluded that the port would be environmentally preferable to the current alternative of reverse lightering because it results in fewer VOC emissions, and also that the port would not affect domestic oil prices, and thus is consistent with energy sufficiency.
Mr. Peterson, the petitioners, as you know, filed a 28J letter urging the court to consider our recent decision from a few weeks ago in O'Reilly v. U.S. Army Corps. Give us your best argument why that case is distinguishable.
Your Honor, the NEPA analysis in O'Reilly v. U.S. Army Corps is categorically different than the NEPA analysis here. There, the Army Corps was conducting an environmental assessment, not an environmental impact statement, and did a cursory analysis that involved the use of a checklist in which they checked off boxes that said no significant impact. Here, the agencies conducted a meticulous 900-page environmental impact statement that walked through and gave reasoned analysis for every one of the points. They weren't simply using a checklist to reach a goal. They were taking a hard, objective, good faith look at the environmental consequences of their action. That's what NEPA.
Is the standard arbitrary or capricious?
Yes, Your Honor. The standard's arbitrary and capricious, and here, based on the hard look that the agencies took at all of the topics that petitioners bring, the agencies were not arbitrary and capricious in their analysis. They made a reasoned analysis.
This is a pretty high hurdle.
Yes, Your Honor. And here it's not met.
You say this one was, in that case, in this case, it was substantially more detailed, comprehensive, not conclusory, as I take it. That's your description of that in O'Reilly, you had these conclusory statements unsupported by any data or explanation, whereas in this case, things are substantially more detailed and comprehensive.
Yes, Your Honor, we would fully agree with that assessment. Unless the court has any further questions, the agencies here complied with NEPA and the Deepwater Port Act. They took a hard, objective, good faith look at the environmental consequences from this port, and they supported their analysis thoroughly. This court should deny the petition. Thank you.
Peterson, thank you very much. And for the next 5 minutes, we'll hear from Ms. Stetson on behalf of Spot Terminal Services. Welcome.
Thank you, Your Honors. Good afternoon. My name is Kate Stetson. I represent the interveners Spot and Enterprise. I want to make just one general point about petitioner's approach to the briefing here, and then a couple specific responses to some of the points that Ms. Ancel focused on, in her argument today. The general point is this. It is always eye-catching when a challenger in an administrative case argues that an agency failed to do something or ignored something. That tends to get more attention from a panel than saying the agency didn't agree with my evidence, the agency didn't agree with my expert. But if you're going to make that categorical argument that an agency failed to do something, particularly if you're going to make it more than 6 dozen times in your opening brief, you better be right. And here, with respect to every single one of the contentions that petitioners raise that the agency failed to do something, there is an immediate and significant substantial evidentiary response. In fact, if you undertake the exercise, or if your clerks do, of writing down every instance on one side of a piece of paper where the agency allegedly failed to do something, and then tracked through our brief and the government briefs, you will find ample evidentiary support for every point that the petitioners raised. And I think that, by and large, defeats most of petitioners' arguments. For example, one of the points Ms. Ancel raised today has to do with the ozone issue, and she said it is undisputed that the agency didn't calculate the total ozone from Gulf Link and Spot. If you look at Joint Appendix 24, MAR 24085 to 91, you will find, among other things, a chart on page 24085 that shows the ozone impacts of Spot, of Gulf Link, and of the other proposed terminals. You'll find on those other pages a thorough discussion of the cumulative ozone impacts of those proposed ports. You can also look at 23838 to 23839 with respect to mobile sources, which has become a focus of the argument despite appearing precisely once in petitioner's briefing. 24039 to 41 for a discussion about how the ozone impacts, if they are more than 31 miles apart, did not need to be aggregated. And of course, 23839 to 40, which is the conclusion that you heard Mr. Peterson advert to today, that this port, relieving some of the pressure from those constant reverse lightering exercises, could actually result in fewer emissions overall. So that's one point. Second, what we heard from Ms. Ancel today appears to my ears to be a significant pivot from where the briefing began and ended, which was agency failed to do these 72 different things. What we heard today was essentially a substantial evidence challenge, which is that there was a lack of significant support for various and sundry propositions. First of all, that's a pivot. Second of all, the evidence in this 4,000-page record soundly defeats any contention that the arguments that were addressed were not detailed enough. With respect to, finally, the Rice's whale, I think Mr. Peterson covered this well when he explained that, the conclusion before that 2022 Soldevilla study was that the Rice's whale, to the extent it was present at all in this part of the Gulf, was so rare as to be not necessary to consider for purposes of harm. There's a footnote in the briefing that talks about just how rare this is and makes the point, this is footnote 133 of the record of decision, that vessel strikes on sperm whales were estimated to occur once every 420-some years. Vessel strikes on Rice's whales will be less than that. The rarity of that occurrence in the FEIS was borne out by the study and by the subsequent BIOP and by the record of decision. Finally, with respect to the Deepwater Port Act, to begin with, this timing issue, it is, of course, the height of irony for a petitioner who specifically sought an extension of time, record 40562 to 63, to now complain that the time taken was too much. It would turn things completely on its head to suggest that this entire project should be vacated because the approval didn't happen on petitioner's preferred timeline. And of course, with respect to the Deepwater Port Act's findings, the findings are specific in the record more than once that the necessary findings were made. If there are no questions.
Ms. Stetson, thank you very much.
Thank you, Your Honors.
Ms. Ancel, we'll hear from you on rebuttal.
Your Honor, with respect to the timeline claim, the delay they claim or they refer to deals with the petitioner's request to do a supplemental EIS because MARAD failed to satisfy its NEPA duty to provide notice and language translation to the nearby communities. That SEIS process in the comment period closed and happened early on and before the accrued delay after the Deepwater Port Act timeline expired. That timeline the days continue to run to nearly 2 years after the timeline expired. This is not a nitpicky violation of the statute's plain text. This was nearly 2 years that left the public and communities in limbo about the long-term trajectory of this project. And during that time, circumstances on the ground changed that now have gone unaddressed. Regional ozone was downgraded to severe non-attainment. New projects were proposed in the vicinity that add to the spot's cumulative effects. New evidence of the Rice's whale showing heightened risk to the species. And studies on the urgency of climate change were published that affect the same frontline communities. They had an obligation to issue a decision to deny or approve the project before that timeline expired, and they did not do that. If their review is incomplete before it expires, they have no choice but to deny the project. They had no authority to act outside of that timeline. Also, the Deepwater Port Act covers or protects the interests of the public and the applicant. The Deepwater Port Act and its timeline provide express avenues for public engagement, including setting a public hearing date relative to the final decision deadline in the statute. Also, there are clear avenues to solicit information from both the agency and the applicant during that review time, and there's an explicit judicial review provision allowing any person aggrieved by the licensing decision to bring action in this court. With regard to the precursors in air quality, at the outset of the EIS, it explains that they are evaluating air quality impacts based on federal ozone ambient air quality standards. Ozone is a health-compromising pollution that forms when those precursors mix. Only providing the precursors does not provide the public and decision makers the information or what the ozone contributions are to this region. This is a federal standard. And then they cannot do the next step of determining what the health impacts are of that ozone level. The precursors were simply not enough. And in the table they refer to where they list all of the other nearby facilities to show cumulative effects only provides precursors, and that is simply not enough. And then my final point related to the assertion that somehow SPOT would reduce reverse lightering and the impacts of that reverse lightering. NEPA requires the agency to evaluate the total impacts in the first instance of the project before evaluating or calculating any sort of impact reductions that could occur from the project moving forward. And that is to ensure decision makers have a full understanding of the benefits of what those impact reductions could be. They can't possibly know those if they don't know the total impacts first. That was this Holding and Sierra Club versus FERC out of the DC Circuit. Here, they did not do the initial total impacts analysis when it came to total ozone, when they omitted the vessel tankers. They also didn't do that for spills, as I discussed earlier. And this is the most papered over EIS I've seen, and just to bring back to the point where they provide over and over again conclusory statements without providing what the effects could be on these well-studied populations of the Gulf of these projected spills for spot. Furthermore, there's nothing in the record or in the ROD to substantiate the assertion that somehow reverse lightering and its impacts would be reduced as a result of the project. In fact, the record supports quite the opposite. It's not a one-to-one ratio. The sole purpose of SPOT is to take on additional produced crude for export. And even SPOT's own CEO reported that nearshore terminals that rely on reverse lightering will not remain idle if SPOT proceeds. That is at 00157911. And if I may conclude, Your Honor, Your Honors, the NEPA analysis here is severely flawed. It doesn't evaluate the effects on the environment and communities, and they did not file the requirements of the Deepwater Port Act statute, and therefore we ask the court to vacate and remand the decision. Thank you so much.
Ms. Ancel, thank you very much. We thank all the attorneys for their able advocacy today. We appreciate it, and the case is submitted. So as